Well, welcome everyone to today's webinar on transition to adulthood, and it's a family training. I just want you to know that even though it is a family training, and we are of course welcoming all parents, legal guardians, and caregivers of transition-aged youth with special health care needs, but we're also happy to have any agency or school staff join this family training. We certainly want to recognize our facilitators today, Alejandro Escato, Coffee Dixon, and myself, Rochelle Swanson-Holm, and would also like to thank Adrienne Silva for assisting our Spanish-speaking families by providing interpretation. So I also want to be sure to thank our sponsors, which are our Child Health Specialty Clinics and the Iowa Regional Autism Assistance Program, both part of the University of Iowa Stead Family Children's Hospital, Iowa's Developmental Disability Council, the DD Council, and Iowa's University Center for Excellence in Developmental Disabilities. I'd also like to have the honor to introduce our speaker today on guardianship and shared decision-making. And Jennifer Donovan is the public guardian for the state of Iowa, and she oversees Iowa's Office of Public Guardian. She received her law degree from the University of Iowa College of Law, and prior to joining the Office of Public Guardian in 2018, she practiced law for 11 years as a staff attorney at Iowa Legal Aid. She's a member of the Guardianship Association of Iowa Network, in other words, called GAIN, and the National Guardianship Association, and the Iowa State Bar Association. Before Jennifer begins, I'd like to just go over a few of the logistics. So if any of you have questions throughout the webinar, if you would type those questions into the question box, you'll see that on your panel. And then also, if you're having any technical problems, you can type those questions into the chat box so Alejandra or Coffee could help you with those during the presentation. Today's slides can be downloaded. They're in the handout section on the control panel as well. So you're sure welcome to click on the file that you want and upload it to your computer. So with that, we'll welcome Jennifer and thank everybody for attending. And we'll answer those questions at the end of today's session.
All right. Well, thank you very much for having me today. I'm really excited to do this presentation. And I will say that talking with transition-aged youth, parents, caregivers, that really is the part of this job that I think is my absolute favorite. So I'm very, very excited to provide probably an overwhelming amount of information, I'm not gonna lie, and then take questions at the end. So let's go ahead and kind of dive right in because I do have quite a bit to talk about, and I want to make sure we have time to hit on questions because there are always questions I've found. So I'm going to give you just a real brief overview of what the Office of Public Guardian is, since a lot of folks have not heard of us. The Office of Public Guardian is a state program. We're housed within the Iowa Department on Aging. And the Office of Public Guardian has three main functions. So one is that we actually serve as guardian and conservator of last resort. So we're the last option if there's nobody else out there that could do it, for Iowans 18 and older who have no one else who could serve in that role and don't have the resources to compensate a private guardian or conservatorship provider, and whose needs can't be met by less restrictive alternatives to guardianship and conservatorship. We also provide information and referral to the public about guardianship, conservatorship, and alternatives. And we provide training and education for guardians and conservators. So we do a lot of these types of presentations, and then field calls and emails from folks who have questions about guardianship and conservatorship, or other options that we'll be talking about a little bit today as well. So I'm going to start out with some of the basics relating to guardianship and conservatorship, just to make sure that folks have a basic understanding of how guardianship and conservatorship work and what's involved with those systems. So what are guardianship and conservatorship? They're both legal processes where the court is involved, and the court is appointing someone to make decisions for another person who's not able to make or communicate their own decisions. We'll hit a little bit of terminology. The person for whom a guardian or conservator is appointed is called the protected person. In the past, you might also have heard the term ward used for a person who has a guardian or a conservator. We're going to use the term protected person throughout this presentation because that's the term that's used in Iowa's guardianship laws now, under the changes that went into effect at the beginning of January of 2020. The main difference between a guardian and a conservator is in the type of decisions that they're making on behalf of the protected person. So guardians are making decisions about the protected person's physical care. This is going to be things like their housing, their education or employment, their health care, the services that they receive, those types of things. A conservator, on the other hand, is going to be making decisions about the protected person's money or property. So these are going to be financial decisions on money, property, investments, making sure that expenses are getting paid, managing income that's coming in, those types of things. In order to find that a person needs a guardian, the court must find that the person's decision-making capacity is so impaired that they're unable to care for their personal safety or to provide for their basic necessities, such as food, shelter, clothing, or medical care, without which physical injury or illness might occur. So this is the standard. This is what needs to be proved when you're filing a guardianship case, going in front of the court. This is what needs to be proved to the judge in order for the judge to enter an order saying that the person needs a guardian. The legal standard for a conservator is pretty similar. In order to find that a person needs a conservator, the court must find that the person's decision-making capacity is so impaired that the person is unable to make, communicate, or carry out important decisions concerning the person's financial affairs. So when we look at those standards, we kind of need to break that down because, and you'll notice that I've bolded the part about decision-making capacity. That's really the key to all of this, and the part that's important to know when you're considering, is guardianship or conservatorship appropriate in a particular situation. A lot of times people will look at guardianship as being very similar to the parent-child relationship. And for minor guardianships or conservatorships, where someone other than the parent is serving as guardian or conservator for a child or a teenager, that's pretty accurate, really. Adult guardianships, though, are a little bit different. And that's because adults are presumed to be competent, which means they're presumed to be able to make their own decisions. And I talk about adults like it's something different. I'm an adult, you're all adults. We're presumed to be able to make our own decisions, right? So if we think back to our 18th birthday, we were excited to become adults because that was the point at which we were allowed to make our own decisions. Our parents didn't get to decide things for us anymore. So for an adult, having a guardian or a conservator restricts that legal right to make their own decisions. And obviously adults aren't always going to make good decisions, right? We've all made bad decisions. Some people make lots and lots of bad decisions. when we look at those legal standards, it's not just making a bad decision or making multiple bad decisions that means that someone needs a guardian or conservator. Bad decisions alone don't mean someone should lose their right to make their own decisions. What we're really looking at is the ability, the capacity, the capability of following the decision-making process to make a decision. Sometimes someone will have an injury or an illness or a disability that affects, their ability to make decisions. They might need help making decisions, or they might be unable to make their own decisions. But we don't just look at that disability or a certain diagnosis or whatever to automatically determine, oh, this person is going to need a guardian or conservator. We're really looking, at an individual basis at that decision-making capacity. So when I talk about decision-making capacity, what am I talking about? Like, we all make decisions, but we don't necessarily think about how we make them or what goes into making them. So decision-making capacity is what we look at when we look at those legal standards that the court is looking at. Decision-making capacity refers to the ability to understand information. So that's learning information about a topic. For example, I give the example of somebody who maybe has diabetes. That would be the ability to learn information about diabetes, what it is, how it can affect the body, what kinds of medications or treatments are available for it, those types of things. It also involves appreciating how that information applies to the person's own situation. So that would be the person being able to say, oh yeah, I have diabetes and this is what it means for me. This is what happens, to my blood sugar. These are the foods that I can and can't eat, or the effects that those foods have on me. These are the medications that I take. This is what happens if I exercise, all of those types of things. How did that kind of abstract information apply to my situation? The third component is reasoning. So that's using reasoning skills, things like weighing the pros and cons of different options to kind of make decisions. And then the fourth component is expressing a choice. So that's actually making that decision. So you've weighed the pros and cons, and now you pick one, and then communicating that choice out to others. So those are the four components that we look at with regards to decision-making capacity. And an individual can have challenges with one or more of those different areas. So it's also important to look at ways that we can increase someone's decision-making capacity, because some folks will have some level of impairment that affects their decision-making capacity, but they may still be able to make decisions with some help. The first three of these strategies are ones that can help people better understand information. One of those would be to explain things in plain language. As a lawyer, I'm definitely guilty of using a lot of legal jargon. Sometimes it's unavoidable. Sometimes there are words that mean something in a legal context, right? And so we have to use those particular words. Other times, we don't really have to use the big word, we just like them. So as a lawyer, learning to explain things in plain language to people who didn't go to law school, don't practice law, but still need to have an understanding of what's going on, that's a really key skill. Medical terminology is another area. Doctors and nurses are going to use medical terminology that people without that training may not be familiar with. So the more that you can avoid using that jargon or technical terms, the more that you can explain it in ways that people will understand, the better able they are to learn that information and then ultimately be able to apply it and reason with it and make informed decisions. Another thing is asking questions to ensure understanding. Sometimes you're explaining something and the person you're talking to is nodding along, like you're like, yep, they're getting this, and you get a little ways down, and then they ask you a question and you're like, oh, you didn't understand any of what I just said, or or you ask them to do something and it's just clear that they really weren't getting it, but you thought they were. So stopping periodically, asking some questions, open-ended questions work better because then they have to kind of repeat something back or re-explain it to you. And then you can catch the areas where maybe they didn't understand and you can try to re-explain it. Another thing that is really, really key is using needed communication supports. Not everybody is going to be able to communicate in the same ways or receive information in the same ways. So making sure that whatever supports they have that they need are available to them improves their ability to take in and communicate information. So someone who has a vision or hearing or speech impairment might need materials in a different format, or they might need to make sure that they have their glasses or their hearing aids or a sign language interpreter or their augmented communication device, whatever it is that helps them, receive and communicate information. Someone who doesn't speak or understand English might need an interpreter who speaks their primary language. You thought, oh no, they don't understand this. Well, they do if it's in their primary language. So those are all really key ways to help make sure people understand information that's available to them. The other ways to kind of support and increase decision-making capacity, focus on kind of learning those skills that are involved in decision-making, because decision-making is a skill, just like any other skill that we learn. And the more that people practice at it, the better they get. So these are some strategies to kind of help practice that skill. If someone is having trouble applying information to their situation or weighing pros and cons of different options, it might help to use like social stories or personal examples from someone else. Sometimes having that concrete example can help a person make sense of more abstract ideas. So if somebody is trying to decide something in their own life, giving examples about someone else who faced a similar decision, and what they thought about, what they considered, how they made a decision, might help that person say, oh yeah, I would probably make the same decision, or oh, I would find this other thing more important, so I might make a different decision. That can help learn some of those skills. Sometimes folks will find a really big decision very overwhelming and daunting, and that'll make it hard for them to make that decision. Most big decisions can be broken down into smaller steps that you can tackle, one piece at a time. So that helps avoid that overwhelm, and it also can help kind of avoid avoid losing sight of their goals or priorities, because you can refocus in on those at each step of the process as you go. Another thing that's really useful for parents and caregivers of teens and young adults, and useful for anyone who's serving as a guardian or conservator, is modeling the decision-making process. So this is you talking through and showing how you're making a decision, whether that's a decision in your own life or whether that's a decision that you're making on behalf of your child or your protected person. You're walking through, okay, here's the information that I gathered. Here's how that affects my life or your life. Here are the different options. Let's weigh those pros and cons. Let's figure out, what's important. And now here's how we're going to choose which way to go, and here's who we need to tell about that and how we're going to do that. So that really helps show that whole process, start to finish. And if you're working with someone else, it helps them be involved in that process. So if they're making, if it's a decision for them, they're as involved as they can be in making that decision. So they're starting to learn to make those decisions for themselves. There are a lot of important things to consider before pursuing guardianship or conservatorship. So these are some things to think about before you go call up a lawyer or decide to go to court to start that process. The first thing to think about is, does the person meet the legal standard? that we talked about. If they don't, then they don't need a guardian or conservator. There may be other options that will help them to be able to make decisions, or that will help them to be able to carry out some of those decisions. So we want to remember that we're really looking for that significantly impaired decision-making capacity when we look at guardianship or conservatorship. The second is, are there less restrictive alternatives that could meet their needs? Because guardianship and conservatorship restrict an adult's rights to make their own decisions, you want to look at any other options that are less restrictive beforehand and make sure that guardianship and conservatorship are really the only option that will work. So that would be considering things ranging from informal supports, or like a representative payee, using a power of attorney, using supported decision making, or even if guardianship or conservatorship are necessary, can they be limited in some way? And we'll talk a little more about what each of those things means as we go. Then the other thing to consider is, whether the potential guardian or conservator is prepared for the responsibility. Not everybody who has a guardian or conservator is going to need one their entire life, but it usually is a long-term prospect. It's not something that's just used real short-term for a few weeks or a few months. It's usually going to be a fairly long-term prospect. So being prepared for that long-term responsibility, and being prepared for what might need to happen, what transitions might need to take place down the road if the guardian or conservator wouldn't be able to serve for as long as the protected person would need it. So parents considering guardianship for a child that's turning 18 or for a young adult should think about what happens when I am aging and maybe no longer able to do this, or if I pass away, who's gonna step in, and have that plan. Is there, is it a sibling? Is it another family member? Is it a friend? Is it a private provider? Who else would step in? Making those arrangements in advance is very important. The potential guardian or conservator also needs to know about their duties to the protected person and to the court. So in terms of their duty to the protected person, they have a duty to make decisions for the protected person that put the protected person's interests first. So that would be doing things like considering what the protected person would decide if they could make their own decisions, and not trying to impose their own wishes or their own preferences. If they know that the protected person has different goals or different preferences for themselves. My favorite example of this, the example that I like to give, is my younger brother. Our mom and I are his co-guardians. Since he was a small child, he has been fascinated with tattoos, loves tattoos, desperately wants to get a tattoo. Mom thinks tattoos are like the grossest thing ever, is totally not down with it, which I think, makes him want one even more. He's capable of understanding, what's involved with a tattoo. Clearly has a strong preference for it. What we really have to consider isn't our own personal feelings about it. Would we want one? Would we not want one? Do we find them distasteful or not? But really whether he or the staff in his group home would be able to adequately care for it as it heals, whether he'd be able to tolerate the actual experience of getting one, those types of things. If he is, then it's probably a decision that he should get to do. So that's just kind of an example of how that can work from a practical perspective. Every time we talk, he asks when we're going to go get his tattoo. The other thing is that a guardian or conservator has duties to the court. The main one is filing reports or accountings every year. They need to do their care plan at the beginning, and then file their annual reports, because this keeps the court informed about what's going on in the guardianship case, what actions they're taking on behalf of the protected person, and allows the court to monitor in case there's any problems or issues that might arise. The process, the actual steps that you take to establish a guardianship or conservatorship, it all starts with filing a petition with the court. The petition is the paperwork that tells the court basic information about who's involved in the case, who is the respondent, why do we think that they need a guardian or a conservator, who is the proposed guardian or conservator, why are they qualified to serve in that role, is there anyone else that might need to know about the case, whether that's other family members or caregivers, or maybe the person had signed a power of attorney and their agent should know that the case has been filed. The respondent has a right to be served with notice of the case and a copy of the petition. So they get a copy of the paperwork that's been filed. They need to know, that a case has been filed alleging that they need a guardian or a conservator. They also have the right to be represented by an attorney. So the court will appoint one for them, or they can hire an attorney to represent them. And they have a right to participate, in the whole process. So attending the hearing, and being a participant the whole way through. So if they disagree with whether they need a guardian or conservator, they have the right to explain to the court, and be represented and present any evidence to support their position, and to participate in the hearing and all of that. Beginning this year, January 1st of 2020, the court is now required to conduct background checks on all proposed guardians and conservators. The background check includes Iowa criminal records, the Iowa Child Abuse and Dependent Adult Abuse Registry, and the Sex Offender Registry. So they're not going back, if you were appointed as a guardian 5 years ago, they're not going to go back and run the background check on you, but any new cases that are being filed now, they're running those background checks. The court is required to schedule a hearing. At the hearing, the court will hear testimony and witnesses, testimony from witnesses, and receive any evidence about why the respondent does or doesn't meet that legal standard to have a guardian or a conservator appointed. Those are the parts of the process that are required. Those are going to happen in every case. There are some other things that might happen between when the petition is filed and the hearing, but they might not. So the court might order a professional evaluation of the respondent by a doctor or a psychiatrist or someone who's qualified to assess the respondent's decision-making capacity. They might not need to order that if there's already enough information from other sources, or if that type of an evaluation has already been done and is being submitted to the court. The court might appoint a court visitor. This is someone who can investigate the situation. They're kind of the eyes and ears of the court outside of the courtroom. So they can actually go and interview people, go see where the respondent lives, and come back and make recommendations to the court about the case. The court might also order parties to engage in mediation. This is less common because oftentimes there isn't really anything that's going to be resolved through mediation in a fairly straightforward guardianship case. Mediation is most useful in situations where maybe there's a family dispute or a dispute between the guardian or conservator and the protected person about a particular decision. We're getting a third party involved to kind of try to resolve that, could potentially work out well for both parties, and avoid having the judge, kind of make that decision for them. If the court finds that, yep, the respondent's decision-making capacity is impaired enough that a guardian or conservator should be appointed, then the court needs to consider whether a limited guardianship or conservatorship would be appropriate. In a limited guardianship or conservatorship, the guardian or conservator only has the authority to make decisions in certain areas, and the protected person is going to retain the right to make their own decisions in all other areas of their life. Judges have been required to consider whether limited guardianship is appropriate for many years, but in practice, most of them don't unless someone involved in the case suggests it. So some of the changes to the guardianship laws that went into effect this year are hopefully going to make it a little bit easier, a little bit less of the default for judges to go full guardianship or full conservatorship, a little bit easier for them to parse out those different areas and say, okay, here are areas where the guardian or conservator should be making decisions. Here are areas where the protected person should be making their own decisions. If the court appoints a guardian for a person, then there are a variety of different responsibilities that the guardian might have. The exact responsibilities will be spelled out in the order that appoints the guardian. So for any service providers that are on this call, it's very important to get a copy of that court order and review it, because that's what's going to tell you which decisions the guardian is responsible for and what rights the protected person retains. In general, the guardian's responsibilities are going to be related to the protected person's non-financial needs. So it's mostly going to be personal care type decisions. Things like making sure the protected person's basic needs for food, clothing, shelter, and medical care are being met, helping the protected person access education, training, vocational, and other professional services they might need, helping the protected person pursue social and recreational activities and develop and maintain supportive relationships, those types of decisions. The guardian's most important responsibility is to help the protected person develop and maintain self-reliance. That's really the foundation on which all of those other responsibilities are built. So when the guardian makes decisions for the protected person, they should be involving the protected person in those decisions as much as possible, and they should be making decisions with the protected person's goals, wishes, and preferences in mind. There are certain powers that require specific court approval. So there are certain types of decisions that the guardian can't make unless the court has specifically authorized them to do so. One of those is changing the protected person's permanent residence to a nursing home, other secure facility, or a secure portion of a facility that restricts the person's ability to leave or have visitors. So if you're just moving, they live in an apartment and they want to move across town to a different apartment that's closer to their job or closer to a bus line or nicer or whatever, that's fine. That's not going to be a more restrictive residence. You can move apartments, you can move houses, what have you. If they're in a facility that is restrictive and you're moving them to another facility that's the same level of restriction, that's also going to be fine. It's when you're moving from that community setting, whether it's living with family, whether it's their own apartment, whether it's a group home that they're able to come and go from and have visitors at, into a setting where that's more restricted and they're not able to come and go and have visitors, that's when you need to get court approval to make that move. There are also 3 kind of medical type decisions that require specific court approval. Consenting to the withholding or withdrawal of life-sustaining procedures. So if you know that the person that you're serving as guardian for is nearing the end of life, or that's something that may come up, you want to ask the court to authorize you to make those end of life care decisions. A guardian also needs to get specific court approval before consenting to the performance of an abortion on the protected person, or before consenting to the sterilization of the protected person. So those are kind of the two other categories that require specific court approval. Other types of things, generally, what happens is you include in the care plan that you file at the beginning of the guardianship kind of the types of decisions that are likely to come up. And then the court will give you the authority to make those types of decisions. So maybe you know that the protected person has a heart condition, has had a few surgeries over the years, is likely to need a couple more. You include that in the care plan. The court's going to say, yep, you're allowed to make decisions regarding the need for those types of surgeries. Now, maybe something will come up later on that wasn't included in the care plan, and you want to go back to court and get approval for that. But generally, you can kind of ask in advance or make sure that it's included in those powers if you know that that's something that you're going to need, a type of decision that you're going to need to be able to make. So kind of mentioned a little bit the care plan and how that works. The initial care plan is due within 60 days after the guardian is appointed, and that's going to address, here's what the protected person's needs are with regards to all of those areas we talked about: housing, medical care, education or employment, helping with social and recreational activities, maintaining relationships, those types of things. Here's what they need with regards to that, and here's the guardian's plan for how to meet those needs. After that, the court's gonna, review that report, approve it once it's ready to be approved, and after that, every year, the guardian's gonna file a report saying, here's what we did with regards to the plan, here's what needs to be changed, and then you file that annual report each year. In the past, folks might be familiar, some of the judges did waive those annual reports and said, oh, they only need to be filed every 2 years or every 3 years or every 5 years, or there were some judges that said, nah, you never have to file an annual report. That's no longer happening because those reports really are the way that the court finds out if there's a problem. So it's really the only way that the court has that oversight over the guardianship. So they are very important. We've seen cases where folks stopped filing the annual reports and the guardian wasn't involved, wasn't participating. Service providers couldn't get a hold of them. Maybe they'd even passed away and nobody was aware what needed to be done to let the court know. Or folks who were filing an annual report and literally photocopying last year's, not even changing the dates. And again, turning out not to be really appropriately involved with their protected person's care. So having those annual reports each year allows the court to see what's going on and kind of monitor those guardianships. So on the flip side, what does a conservator do? If the court appoints a conservator for a person, there are a variety of different responsibilities that the conservator might have. And again, it's really important to look at that court order that appoints the conservator, because that's going to be where you see what authorities they have. Generally, the conservator's powers are going to be relating to financial decisions. So the conservator may be responsible for managing the protected person's money and property. The conservator has a fiduciary duty to the protected person. What this means is that the conservator has a duty to manage and use the protected person's money and property for the protected person's benefit. So the conservator can't spend the protected person's money on things for the conservator or the conservator's family or friends. The conservator has to make prudent decisions about how to save or spend the protected person's money. A lot of people used to think, oh, a conservator needs to preserve the protected person's money and property for the future, not spend it on things now. That's not really accurate. The conservator just needs to balance out those current needs versus future needs and try to make decisions to ensure that, you know, there's going to be adequate resources to meet both the current and the future needs. There were some big changes this year that went into effect on January 1st. The biggest change is that the sections of the law that used to spell out kind of default powers for conservators, those were deleted. So conservators will only have the powers that are specified by the court in the order appointing them. They're going to have very few default or automatic powers. Folks who've been a conservator in the past, that switchover is happening. By now, pretty much everybody's filed their annual reports during the year. We're almost to the end of the year. That switchover is happening when that annual report is due. They file their initial financial management plan, which is the same as the care plan for a guardian. And that determines what powers they'll need going forward. And so that's kind of when the switchover is happening, so folks didn't just lose their powers on January 1. But that means that order and looking at that financial management plan, that's going to be really important to see exactly what things the conservator is allowed to do. Because if it wasn't laid out in the financial management plan, it probably wasn't included in the powers that were given to the conservator. So the conservator may need to go back to court to ask for additional powers if something new comes up, if the protected person, you know, has a new source of income, or they inherit something, or they obtain a new item of property, or there's a need to sell something. There may need to be changes to those powers. The other big change is that all conservators are required to have a bond or an equivalent alternative in order to protect the protected person from the conservator mismanaging their funds or property. We talked about before, guardianship and conservatorship aren't always, you know, permanent lifelong things, but they are usually long-term arrangements. They're basically 4 situations in which a guardianship or conservatorship will terminate or end. If it's a minor guardianship or conservatorship, so relating to somebody under 18, it automatically ends at the 18th birthday. So if that child will need a guardian or conservator as an adult, then a new petition needs to be filed to establish that based on the adult guardianship and conservatorship standards. When the protected person dies, the guardianship or conservatorship ends. That's the point at which then the guardian or conservator would file their final report with the court. If the protected person's decision-making capacity improves and it's no longer impaired, they no longer need a guardian or a conservator, then either the guardian or conservator or the protected person can ask the court to end the guardianship or conservatorship. Or if there's another reason that it's not necessary, the most common one would be a conservatorship where maybe there was some money or property to be managed and it's been spent down, and now there's either whatever's remaining the protected person can manage for themselves, or maybe it's something like Social Security benefits, and there's a representative payee, and so there just isn't need to have that conservator involved anymore. Then that would potentially terminate or be a basis for termination as well. Folks always want to know about the costs involved in guardianship and conservatorship. The exact costs can vary quite a bit. Most of them are assessed against the respondent or protected person. Very rarely is anything assessed against the petitioner or the guardian or conservator themselves. If the protected person is indigent, then most of the costs can be waived or assessed to the county where the case is filed. So I've included a chart that kind of goes through different categories of cost, and then who would be responsible for paying those. The only thing that the petitioner is always responsible for is the cost of the background check, which I think is like $15. The other thing though that comes up is usually the attorney's fees for the petitioner, whoever's filing that guardianship. There just isn't a provision in the law for that to be paid by the county or by another source. So that's often something that that the petitioner is gonna have to deal with. There are sources, through Iowa Legal Aid, through the legal clinics at University of Iowa and Drake, through the bar associations. There are ways to find free or low cost legal services. So if that's something that you're concerned about, reach out to our office and we can help you find and access those resources throughout the state. So I realize we're going a little bit long here. I do want to be able to have time for some questions, but I also want to talk about less restrictive alternatives because I think they're really important. So we've talked a little bit already about kind of how guardianship and conservatorship restrict an individual's rights to make their own decisions. So we can look at some other types of supports and we can look at them kind of on a spectrum. Let's see. At one end of that spectrum, we have autonomy and self-determination. So that's making decisions for yourself. At the other end, we kind of have the loss of rights and more dependence on someone else. That would be more in line with full guardianship. And then in between there, we have a variety of different things. Limited guardianship, or like a representative payee. Those are going to restrict rights, but only certain rights. Something like a power of attorney is going to fall kind of in the middle, because you are giving someone else the authority to make decisions on your behalf, but you're choosing them and you're giving them instructions about, what types of decisions they're allowed to make. And then something like supported decision making, you're still ultimately the one making your own decisions. You're relying on others to support you and help you in making those decisions. So we can kind of look at those along the spectrum. So supported decision making is a relatively new alternative to guardianship, but really it's the way most of us make decisions. It got a name. It can make use of various tools to help a person make their own decisions, and it can be informal or it can be formal. If it's informal, it's really the same way that most of us would ask our friends and family members and professionals to help us make a decision about whatever, buying a car, fixing something in our house, making a decision about medical treatment. Truly anyone can use supported decision making. At its more formal end, some states have actually added it to their laws as an official alternative to guardianship. In these situations, usually there's a written agreement between the person and their supporters that sets out what role each supporter will play in helping the person make decisions. And there are a couple of really good kind of national resource centers. I've included the links for those just in terms of getting more information about what supported decision making is or how it's worked in different states. Samples of some of those agreements that are used in different states. They're excellent resources. Probably the easiest tool that can be used to help someone with decision making is a release of information, and especially for parents of young adults. A lot of times that 18th birthday is stressful because you're no longer going to automatically have access to information. You don't necessarily feel like you have to be the one making all of the decisions, but it's that sudden cutoff of even being able to talk to the doctor or talk to the school or wherever else that feels really scary. A release of information is something that a person can sign to authorize another person or organization or government office or wherever to share confidential information with someone else. So a lot of times that can be really useful to say, hey, would you sign a release at your doctor's office, or would you sign a release for the school to be able to share information with me so that I can help you, make decisions about these things, or make sure you're getting to your doctor's appointments, or what have you. Another really common decision-making tool is a power of attorney. Powers of attorney are written documents in which one person is giving another person the authority to make decisions on their behalf. The person who's giving authority is called the principal, and the person who gets the authority to make decisions for the principal is called the agent, or sometimes the attorney, in fact. But agent is one word, so we'll go with that. Power of attorney is really a sharing of decision-making authority, because the principal still has the ability to make their own decisions as long as they're able to. There are two kinds of power of attorney. One is a durable healthcare power of attorney. This one allows the agent to make healthcare decisions on behalf of the principal. It only takes effect when the principal's physician certifies that the principal is not able to make their own decisions. If the principal later regains the ability to make their own healthcare decisions, then the agent should no longer be making healthcare decisions for the principal. The principal should be making their own decisions again. The principal can include instructions in the document about types of decisions they would or wouldn't want made in different circumstances. So they can give their agent a lot of useful information and direction. The other type of power of attorney is a general power of attorney. This one is usually used for financial decisions. It can be super broad. You can give somebody the authority to make all sorts of financial decisions for you, or it can be really specific and limited to one transaction on one day. It can take effect immediately upon signing, or it can take effect in the future, either on a set date or when a certain set of circumstances takes place. The agent has that same type of fiduciary duty to the principal. So they can't use the principal's money for their own benefit. They have to follow the principal's instructions and wishes with regards to how their money and property are being managed. How to execute the document. Basically, the principal has to be an adult. They have to have the ability to understand, the capacity to understand that document. They don't necessarily have to be able to make all of their own decisions, but they need to be able to make the decision about whether or not to give this other person the authority to make decisions on their own behalf. And it needs to be voluntary. So whenever I hear somebody say, I need to get power of attorney over my whoever, that's always a red flag for me, because it needs to be given by the person. It's a lot like hiring an employee. You can't force somebody to let you work for them. You've got to be willing to trust that agent to handle things for you. The document must be in writing. It doesn't have to be any particular type of writing. It can be handwritten, it can be typed, it can be a form with blanks to fill in. All it needs to include is the name of the agent, what responsibilities and authorities are being granted. It has to be signed and dated by the principal, and it either needs to be notarized, or if it's a healthcare power of attorney, it could be signed by two witnesses who they watched the principal sign it and they watched each other sign it. Couple of key things to know are that the principal retains the right to make their own decisions as long as they're able to, and an agent can't overrule a decision by the principal. Powers of attorney are revocable, so they can be revoked. The principal can take away the agent's authority. It's possible to revoke them and not have the capacity to execute a new one. So that's something to be aware of, that they may revoke it, and then if they don't have the ability to sign a new one, then there's potentially the need for guardianship or conservatorship at that point. there aren't any reporting requirements. They're not registered anywhere. They're not overseen by the courts in any way. So they really are kind of a private matter between two individuals, which means you need to share a copy of the document with anyone, banks, doctors, whoever you're interacting with that needs to know about the agent's authority. And I am seeing the time, so I think I'm actually just going to stop here. We do have some information on some money management tools because there are a variety of those. But I think if folks have more specific questions about what those are, I'm happy to, happy to get calls or emails from folks with questions about those. But there really are a lot of different financial tools specifically for folks with disabilities that can help avoid that need for a conservatorship. We do also have a couple of good resources for guardians and conservators. So I want to highlight that, both the Guardianship Association of Iowa Network and the National Guardianship Association. So you've got websites for both of those organizations on here, as well as my contact information. So feel free to call or email with questions, and I will try my best to answer them. But now I would like to be able to take any questions that have come in through the chat.
Great. Well, Jennifer, that's Rochelle, and we certainly want to thank you for your presentation. This is a really important topic for a lot of parents and guardians, and so I know we do have a lot of great questions, so I want to make sure we get a few of those answered. So, does the guardian need to live in the same state as the ward?
Not necessarily. Generally in Iowa, the preference is for a guardian in Iowa. An out-of-state guardian, the court may want a co-guardian who is an Iowa resident, but that's not 100%. There are definitely cases that are an exception to that. So that's something that's kind of going to depend on the situation and the judge's preferences, and probably the relationship between the protected person and the guardian, and how close they are. Do you live in Omaha and the protected person lives near Council Bluffs? That's you could have an Iowa guardian that lives farther away. So it's going to vary from case to case, but generally there is a preference for Iowa residents.
Okay. Our next question is, why would a person choose a court-appointed attorney for the protected person rather than hiring an attorney? And are there pros and cons?
Cost is going to be the main one. If they don't have the funds to pay a private attorney, the court-appointed attorney's costs are going to be charged to the county. Also, a lot of the court-appointed attorneys do this. In most counties, they sign up on a list, so they let the court know that they're available for appointments in these types of cases. So a lot of them really are very experienced at representing folks who are the respondent in a guardianship case. So a lot of times you'll think, oh, a court-appointed attorney is probably not going to be quite as good. That's often backwards. They're a lot of times going to be the folks that are really have the most experience handling those types of cases, precisely because they're signing up to do it.
Okay. What if they don't understand what a guardian entails? I assume that means
the protected person.
Right.
So that's going to be something for the court to consider. There are definitely folks that would not even understand what guardianship entails. the attorney that represents them has a duty to do the best that they can to try to represent them as in the same manner that they would any other client. That may be a situation where a court visitor is appointed who can also go in and kind of make recommendations and present a little bit more of that evidence to the court of saying, hey, this person really doesn't fully understand what's going on. And that's gonna, the court's gonna take that into consideration in determining, are they able to understand things well enough to make their own decisions? If they don't fully understand what's involved in a guardianship, that's probably going to be evidence of some significant limitations in their decision-making capacity in other regards too.
Well, I'm afraid we're out of time, and we do have some other questions. And so I think what we'll do is send those questions to you, Jennifer, and get your answers. And then we can probably send those out to the listserv of those in attendance today. So
that sounds great.
Okay, great. So thank you again. And I just want to let everybody know that they're just after you close out of the webinar, an evaluation will pop up, and we certainly appreciate if you could complete that evaluation so that we have more feedback and good ideas for growth in our webinars and our face-to-face transition to adulthood activities. Also, if any parents would like some personal assistance from experienced family members, you can contact Diane Brenneman at universityofiowa.edu, and her email address is right there, and or her phone number. And a family navigator can help you with emotional support, systems navigation, and connect you to some resources. We can also help you get connected with a family educator partnership, and that would be that you could get a hold of Susan Selby at her email and or phone number here, and they are those partnership folks are able to help you understand special education, help support the child and your family through their education connections and things, and then also assist with any post-secondary transition as well. So again, we really want to thank you. Please stay on and do that evaluation. And those of you that posted those great questions, we'll make sure we get the answer to those and get them out to you. And like Jennifer said, her contact information was on the PowerPoint presentation if you downloaded that to your computer, and if not, when we send you an email, you'll have that same information. So thanks again, everybody.